Good morning, afternoon, or evening. I am Stephanie Joy with All Things Social Security and the attorney at Joy Disability. You're about to see what should be a question and answer format type of chat from our live session on a particular topic that we find that a lot of people keep asking about. So I'm sharing it here. If there are pieces that could have been added that weren't added during the live, because it's a kind of a fast-paced Q&A that we do every Wednesday at 1 p.m. You might just find that I added something to the end of it to give it a little more clarity and a little more details for those that are interested in that particular topic. So check to see if that's at the end. Otherwise, enjoy the video. Bye-bye. Okay, Big Todd. Hello, how do you feel on second claims at the same time your first claim is in the Federal Appeals Court? I think it's excellent. 3 new impairments turning 50 in October. Excellent, excellent, excellent. Absolutely. The second you get out of that appeals counsel who rejected you, boom, go file a new claim for the new period. From the day after the judge's denial to the present, if you are still disabled. Absolutely. Absolutely. That's your plan B. And ideally, you're going to want it at the federal appeals level, and it's all going to be wrapped into one big, nice bow, and you have it from way back all the way through. So I think that's good. You did good if you did that. Perfect. That's what I would be telling someone to do or recommending. And you're lucky because it sounds like you have a DLI that's prospective and not cut off because it already expired and you wouldn't be able to do what you're doing. That's why those DLIs that I'm always harping about, guys, you do not want that to be in your rear view window. And if it's right ahead of you, it's going to be in your rear view mirror soon unless you do something about it. So consider doing something about it. That's okay. I don't know what that no is about. Okay. I don't even know what scale that would be on, Lord Derek. My anxiety and depression is over 22 points. Yeah. I don't have those memorized. I kind of look at everything afresh all the time because everything in medicine changes, and particularly in mental health. I'm assuming that means it's pretty bad, though. Dimple says, hi, Tim. Very thankful for my representation. Aw, you're very sweet. I have so many ducks that I sometimes forget about them. Keeping up with them is like checking various zip codes. Yeah, and you've got that nagging representative who's always like, so what if that's not your big major problem? Take the time and go treat. Right? I know. I'm so bad. But it's one of the negative parts about my job. Dimple says, my physical therapist got me to admit that 2 pounds is too heavy to lift multiple times, and my current limit is 1 pound. Okay. So 2 pounds or a few, you could probably do it once here and there, but you can't do it repeatedly. Is that the thing? If it's going to be repeated, it's got to be something very, very light, like 1 pound. That doesn't hurt. Hey, what's up, Tosh? Hey. All right. You were napping, so that's why I didn't feed you anymore. Beth says, only leave with my husband or adult daughter, maybe once a week. FMLA was due to stress and concentration issues. I'm on meds and see a psychiatrist. Okay, so you have more than just were you the one that said just a therapist once a week? Is that you? That's good. Look to the physical. That unless you're like, no, I really am like I'm 20. I'm like Wonder Woman. That's what I would do, is to carve out more jobs at those, even if they're not major, but there are limitations beyond what you can't do this for 8 hours a day physically because it would be painful or something. It helps us, carve those out. Yeah. Do all of your doctor's appointments, does it come up about how you can't leave the house alone? Do they note that she's here with her husband? She's here with her daughter? And the reason why I ask is because it's hard to prove that. So you want to, you didn't used to be. The agoraphobia happened at some point. I'm wondering, was the agoraphobia why you were? Did you get an accommodation to work from home because of diagnosed agoraphobia 17 years ago? If you have that paperwork, that could be helpful too. Do you go to the store? So are you able to go out and about as long as you have a close bud with you? It's like some people can't leave the house at all. Some people, like you can under certain conditions. Out of Order says, oops, thank you for doing this. You're very welcome. Thank you for being here. I really appreciate that. Hey, good morning. I am squeezing this in here before I run out the door for actual private appointment. Someone had asked me about remands. So what is that? Does it affect a lot of people? Quite a bit. actually. Okay, so a remand. A remand is when you have your ALJ hearing, you get a denial decision, you appeal it to the appeals council. And the appeals council, this is one remand. The appeals council decides that there is something that perhaps wasn't handled properly under the law, under the requirements of process and similar, or another appealable criteria. And they decide that it needs to have another hearing. The ALJ needs to go back and do what it failed to do what he or she failed to do, or refrain from doing what he or she did that was contrary to what they're permitted to do. So when that happens, you go back to the ALJ location, shall we say. Your case goes back to where it was, theoretically, before you had your first hearing. And now you're going to have a second hearing. So the first hearing is it's there, but it no longer is going to be the only hearing. Of course, I believe what you said at your hearing still holds water because you did say it under oath. So hopefully it was good. It's funny, I've asked judges on remand hearings, and I've done many of them, rather than always recreate the wheel for some things that have already been testified to. And I always want to know if he or she is going to, that's part of the record, correct? And I don't really get a lot of cozy response. I know it's part of the record. I mean, the ALJ decision was kicked to the curb, but the testimony wasn't. So I've seen, I don't know, maybe no one else asked that question, but I always just kind of wanted to be there that, what the person said before is still his testimony. Now, if the judge wants to go through all those same questions again, which it might, because things do change. I mean, there could be more pain, more limitation, or things could have improved. And the judge is going to want to know that because that could affect the current decision. And the current decision, again, is kind of like a whole redo with the hearing, except cannot avoid the fact that the prior testimony is still evidence, as far as I know. It was not booted, just like nothing that was in the file was booted just because of a remand. Okay. Another way you can be remanded is if the AC, Appeals Council, doesn't find that your appeal had an appealable issue worthy of a remand. They might deny. And I should add that the other alternative to an AC decision is that they could reverse the judge and award you. That's not very typical. I think it's like one, I've had maybe one. So as I was saying, the other kind of remand is when the AC denies review, and now you have 60 days to, if you're going to appeal to federal district court, to do so. I don't do federal district court appeals. I refer my clients that ever need them to folks that do that for their profession. Some of my colleagues, that's all they do. So those would go to them. But what will happen is, and that kind of review, similar to AC appeal, you're not going to be submitting generally new evidence. They're going to be looking to see if there was an appeal issue on what had transpired before. So they're going to reconsider exactly what the AC reconsidered, but maybe in a more sophisticated manner because they are a little more sophisticated and perhaps a little more careful. Because plenty of FTC appeal cases do get remanded back to the SSA to redo it. And that's what a remand would be there. They can remand it back to the SSA. And what I tend to see then is the appeals council kind of looks at it again, and they could either then award it, I suppose, because it's going back, or they get it up, send it back to the OHO, the ALJ, and they get in line for hearing. And generally, I think that's one of the cases that is supposed to be given priority for hearing scheduling, as opposed to as if it was your first bite at the apple going to hearing. I think it's on one of those lists I'd mentioned before when I was talking about, I think it was dire circumstances was another one, but it's for a little expedition in the handling. So going back for a remand, you get all that opportunity to get all those updated records for the next hearing, as if it was your first hearing. And this is why when I tell people after they've had their hearing, but they don't know the results, do not stop pursuing as aggressively as you were your treatment options for all of your little and big impairments. Because if this happens, you're going to need all that evidence from that interim period. And that can really help an ALJ be comfortable making a reverse decision on himself, because the new evidence is stronger. He could see different things. If you do squat, I think he's going to have, just from being human, he thought you weren't disabled under the law before. Even if he thought you were very impaired, he has to follow the law, and he thought he was. Or he thought he had the right result, whether or not he did everything the way he was supposed to do it. So you want to continue to aggressively, robustly pursue your treatment so that your evidence continues to be built as to the diagnoses and the functional limitations that stem from them. So don't stop that just because you have an ALJ hearing. When you get the result that says you prevailed and you're not going to be appealing anything, then you can perhaps take a breather. But then again, remember, only a breather to a certain extent, because by and large, almost everybody is subject to a CDR down the road. So you always kind of want to keep your development of your evidence of your current situation, because you have to always be currently disabled to continue to get benefits going in the future, to be found disabled. So you just want to kind of have the power to maintain that evidence that nobody else has by continuing to follow up with those doctors. If there's no cure and even no treatment, you kind of still want to follow up periodically to get a status of your condition. Okay. It could be diagnostics, updated MRIs, CTs, X-rays, although I don't find those very helpful from an evidentiary point of view. But anyway, so that's remand. It's going back. It's getting remanded back to the ALJ for another hearing. So what was not done or was not done right or shouldn't have been done can be redone the right way. Okay. Doesn't mean you're going to win, but I find that there is in my experience, in fact, I don't think I've ever lost a remand hearing. I don't think, but that's because continue pursuing and don't sit on your laurels because you got another hearing. You have to really, that whole time frame between the first hearing and the second hearing, boom, it should be robust and filled with all of your treatment. What was the other thing? Yeah. And a hearing will probably be as long as, or cover all the bases that it covered before. Remember I was saying, well, what about the other prior testimony? That is evidence, but I don't think it's going to replace the new evidence. And generally speaking, most people, oftentimes, there is a deterioration and a worsening. So you do want to have that new testimony to show that it's gotten even worse. Particularly important if your DLI, date last insured, is still ahead of you, as opposed to behind you, because often it will now be behind you because all this time has passed and you still haven't worked and paid those premiums to earn those credits to keep it going and you haven't been found disabled. Yet another reason to be very aggressive even after your hearing, particularly if you're appealing it. Okay, that's it for now. Remand. It's a second bite of the apple for the hearing. Sometimes it is the only bite you're going to have left. Like I said, if your DLI is expired, passage of time. Remember, you have 5 calendar years max, period, if you're not working anymore at all, even part-time. So if you're curious about how to extend that, I do have videos on kind of like how and maybe some best practices if you are going to go to work part-time to keep getting those credits so that one day you might have enough to regain Social Security disabled insured status or to maintain it because you're still pursuing it because you can't work full-time, even though the SSA hasn't agreed with you. You can keep applying as long as you continue having insured status. And you can do that while being under SGA. So you don't prevent yourself from filing while you're working. You could still file. All right. There's a whole playlist on that, I think. I don't know what it's called. It might be under earnings credits, maybe. Okay. Bye, guys. I hope that helps. Ciao.